Hey, my name is Mark Woodbury. This is my law partner, Daniel Labarra. We're estate planners, and we wanted to give a little presentation today about some of the tips that we usually recommend to clients about avoiding conflict in their families after they pass away, and the things that we can do now from a planning perspective to make sure the kids don't fight, make sure everything goes smoothly, and make sure that your wishes are respected to the extent possible. So I've got basically 5 things that I always tell clients. I say, hey, if you want to avoid conflict after you passed away, here's 5 tips. Here's 5 things we can do. Now, it's not a guarantee. If somebody really wants to file a lawsuit, they are going to file a lawsuit. I can't stop that. I can't prevent that from happening. And they're not rules. They're just, well, they're what you might call guidelines, I guess.
Right.
Take them or leave them. But what I always tell people is, hey, if we're going to do something different on one of these issues, then it makes the other ones that much more important. Now, if you don't care about conflict, if you're more interested in some other aspect of estate planning, like making sure your no good kids get what's coming to them, we can help with that too. Just be aware that's likely to lead to a conflict. If you're okay with that, we're okay with that. The majority of our clients, though, are interested in avoiding conflicts wherever possible. That's the number one question we get. So let's dive right into those. Dan, did you have something you wanted to add there?
I just wanted to add in that the reason that we know of these things is developed over the last probably 15 years or 10, 15 years of practice where we've been involved. We also do a lot of litigation. We do estate planning, but we do the other side of it. When people sue each other, we're the ones that handle those cases in addition to doing it. So we have some good experience to speak to.
That is a good point. The reason we know what causes conflicts in estate planning is because we're so often in there causing those conflicts for people. So let's get to it. For you, though, we're going to avoid conflicts. Okay, so the number one rule I always tell people is be in writing. Your estate plan needs to be in writing. I cannot stress that enough. There is no such thing as an oral will in the state of Utah, and to be honest, a lot of the problems that I see are some kid coming into my office, and I say kid because it's a son or daughter. These people are all in their 40s and 50s, and saying, well, mom told me I was going to get the house, mom told me I was going to get the jewels, mom told me I was going to get the car, whatever it is. And the sister saying, well, mom told me I was going to get the house, mom told me I was going to get the jewels, mom told me I was going to get the cat. Weirdly, a lot of fights over pets, actually. Not all the time, more than I thought, though. Surprised how many fights over pets there are. I know that we've both seen experience with this. For example, I had a case once. It's not exactly that it wasn't in writing, but a guy printed a form will off of the internet and went to mom and said, here, let's fill this in and sign it. And that's not necessarily the end of the world to do that. But one of the terms that mom put into that will that got printed off the internet that they filled in together was that this dude's sister was going to be disinherited. Well, guess who wasn't happy about that when it came up for probate? And guess who hired a lawyer? And guess whose lawyer figured out that all of the signatures were wrong on the will? Okay. Now, this is not exactly a situation where it wasn't in writing, but it is a situation where the writing was done incorrectly. And what happened was my guy paid me $20,000 in attorney's fees. God knows what the other side paid. And at the end of the day, we just had to settle the case and come to a compromise anyway. Nobody ended up with what they wanted. So get these things written down, and my recommendation obviously is come see one of us or some other lawyer and get them written down correctly, but definitely get them written down.
Yeah, I definitely have seen that a bunch of times. I mean, the estate plan is something that people just seem to procrastinate, whether it's because they don't want to think about it or they just don't get around to it. Whatever the reason, they just don't seem to get it done sometimes. And I remember a case where there was a man who died, and he had told people what he wanted, but he didn't write it down. And it ended up, the city ended up suing his family, and the city, in order to get his estate, and nobody ended up with what they wanted. The family lost a bunch of money. The city didn't get what they want. And really, in the end, the only people that won were the lawyers, and that's too bad. So
I remember me working on that case. That was a crazy one. This was a guy, again, this is one of the craziest things I've ever seen. A city up in northern Utah actually filing a lawsuit saying he told us we were going to get all his money when he died. I'm not saying they were wrong. I'm saying it is one of the weirdest things I've ever seen. And what had happened is, he told all his neighbors that and then jotted down a few incomprehensible notes in a notebook. And then we were left to pick up the pieces and clean up the mess. So get these things down in writing. The next thing I always tell people, be equal. And I always have to clarify, equal is not the same thing as fair. Like I said, if you got a bunch of no good kids you really want to stick it to, go ahead and disinherit them all. I'm not going to stop you. And if it's really what you want, I will gladly draw up the paperwork for you. Just be aware that every time you disinherit someone, you give them something to gain by causing problems, by causing conflict, by filing a lawsuit. So if your number one priority is avoiding conflict amongst your heirs, be equal. In my mind, the best, safest estate plan for avoiding conflict is divide everything in equal shares and write checks to everyone. If you try and do anything more complicated than that, you are just raising the odds that someone is going to have a reason to sue. And that actually leads pretty seamlessly into the next point that I always tell people, which is be easy, be simple, be clear. I like to say be easy because it, a little more memorable, but it's it's perhaps more accurate to say be simple and be clear in what your wishes are. I do every once in a while see some sort of complicated estate plan. For example, I had a trustee come into me a few months ago saying, hey, I have a beneficiary that's threatening to sue me because he thinks that he's not getting his full share of what he's entitled to under the trust. I said, oh yeah, that's no problem. I can tell you if you've done it right, I can tell you if you've done it wrong, and help you navigate that situation. Bring the trust in, let me take a look at it. So he brings the trust in, and I swear to you, it may as well have been a calculus problem to figure out what everyone was supposed to get out of the trust. It was, everybody who's older than this age when I die gets this much set aside and it's going to be distributed on this schedule. Everybody that's in a different age range gets this much set aside in principal, and this much of the income goes different places, and they're allowed to get this much of their inheritance if they want to before this age, but this much they have to wait until another certain age to get, and it was a total mess. Now, I am not saying that there are never any circumstances when you need to include a calculation. What I am saying is just be aware that the more complicated you make things, the more likely you are to have a problem between someone and the trustee or the executor or the personal representative, because someone is going to be, maybe the personal representative screwed up the calculation, maybe the beneficiary screwed up the calculation. I don't know. It almost doesn't matter. The point is to avoid conflict, so make the math so easy that a lawyer can do it. That's my rule of thumb.
Yeah, I totally agree. In fact, a lot of times I'll tell my clients, they'll ask me, how can I make sure that the government doesn't get my money after I die? And I say, well, we're going to help you with that. We're going to use these certain strategies to do that. But the thing you should probably be more worried about is how can you make sure that the lawyers don't get your money after you die? And the reason is, if you have a big conflict, a lot of your estate will end up getting eaten up in attorney's fees as your heirs start to fight each other. I remember one case, the man who passed away didn't have a will, and he had married later in life, and he had kids from a previous marriage, and so they had to use the rules of intestacy under the state of Utah. And some parts of that are pretty straightforward. If you talk about it, usually it goes to your kids first and then parents, spouse and things. And the division's pretty straightforward. But some things are not clear. They are not easy and simple like Mark's suggesting. For example, in that case, it was how did we properly calculate the commuted value, is the word that this code uses, of the pension. And it led to thousands and thousands of dollars in litigation to try to determine what that was. And so I completely vouch for what Mark is saying. Be simple, be easy, make it so that anybody can read your estate plan and know exactly what needs to be done.
It also led to many lost hours of sleep for Dan, I can tell you that. And so do Dan a favor, more importantly, do his wife a favor, and make your estate plan so simple that not even I can screw it up, and then Dan has to come in and lose sleep fixing
Right.
it. That's the honest to God truth of it. No, Dan actually raises a good point, especially with the blended family situation. If you have remarried later in life, or even earlier in life, if you're on a second or a third marriage, you are definitely going to want to come meet with an attorney and work out what your wishes are, because, like Dan said, when it comes to your kids, to be honest, if you die without a will, the state's just going to divide everything evenly amongst your children. Now, that's not a reason to not get a will. We've gone through a couple of other reasons why, hey, it's still important to get a will. You want to be clear. You want no questions. Even in cases like that, I get kids showing up saying, well, I took care of mom for the last 5 years. I should get more. And invariably, the argument from the sibling is, she didn't take care of mom. She freeloaded off of her for the last 5 years and didn't pay rent. She should get less. Okay? See that a lot. Either way, come in and get it written down. The point is that even if you do nothing, there is a default in place and everything kind of gets sorted out. It's messy. It's complicated. It's no fun, but everything does go usually where it's supposed to, equal shares to your kids. However, if you're on a second marriage, if you're in a blended family situation, if you have stepkids you want to take care of, if you have a spouse, a second or third spouse that you want to take care of, you definitely need to come talk to us, because it's really, really unlikely that the default statutes are going to be what you would have come up with to take care of your spouse. And to be honest, that is what I see most of when people do come in, is they say, look, my kids can inherit after my spouse is taken care of. That is the number one priority, is taking care of the spouse. This is a little bit off the topic we were on, about being easy and simple, but let's roll with it. If you're in a blended family, please come talk to us, because you really need to get something in place.
Absolutely.
The next thing that I always tell people is be predictable, or the other way to put it is no surprises. Your kids should not find out what's in your will after you are dead. Okay? Makes for a great movie plot, especially if it's a movie involving Daniel Craig. Loved that one. Not good for estate planning, which you may remember if you watched that Daniel Craig movie. Everybody pretty much ended up dead. So closer to the truth than you might think. No surprises. Your kids should not find out after you die what's in your estate plan. And I always tell people this is especially true if there's something to be surprised about. And that mostly means if we haven't followed all of the other rules for avoiding conflict, then this one becomes even more important. If a kid is going to be disinherited, they need to know that now, not after you die. Is that an awkward conversation for you to have with them? Yeah, totally. Terrible conversation. You do not want that conversation. You know who wants it even less? Whoever you left in charge after you die. Okay, I can guarantee you it's more awkward for them than it is for you, and more likely to lead to a lawsuit. Okay, so no surprises. In fact, my recommendation to people is always, well, not always, but it's a standing recommendation. Hey, you may want to consider just making 3 copies of your estate plan and sending it to each of your kids. That way they know what's in it. There really are no questions. Now, yeah, I mean, that's not foolproof. You may need to amend it later on and stuff like that. And if we have to deal with that, we have to deal with that. That's fine. But they should at least have a starting point. So that's my recommendation. Even if you don't give them the full estate plan, even if you don't tell them all of the details, they need to have a good idea. They should not be surprised. I always say, I don't think I said that this time. I'm going to say it again. If I haven't said it before, I'm going to say it again because it's that important. A lawsuit is very rarely, in fact, almost never, a rational decision. I know very, very few people who come into my office saying they want to file a lawsuit and then give me the spreadsheet where they've worked out the cost-benefit analysis and determined that it's going to be profitable. Okay. It is almost always an emotional decision made for emotional reasons. That doesn't mean it's wrong. Like if something's gone wrong and you need to file a lawsuit, you need to file it. That's fine. But the fact of the matter is that it is very rarely a reasoned, rational decision. It is an emotional one. And if you want to take a lot of that emotion out of it, if you want to take the sting out of it, if you want to make sure that your kids are making decisions rationally and not emotionally, then get that emotion out of the way now. Okay, because if your kids find out after you're dead that you disinherited them, they straight up will not believe it. They will decide that it must have been older sister's fault or younger brother's fault. That will happen. That is the case I see the most of in my office on the litigation side. So my recommendation is be predictable, no surprises.
That's a good recommendation. I wanted to just add in real quick that when we deal with all these different types of litigation cases, a lot of times people just think, oh, I'll take care of it later. I'll get it done at some point, or I'll just do it myself. And frankly, I'm a DIYer. I like to do stuff around my house by myself. That's fun. But the stakes there are lower. In the sense that if I mess up my drywall, I can go get some new drywall. Not a big deal. By the way, I recommend that you hire somebody to do your drywall. Don't do it yourself. But
I've seen your drywall. You did fine.
I don't know about that. But when it comes to your estate plan, you only get one chance. If it's not done properly, and you die, now your kids or your heirs or whoever it is that you've decided to leave things to, or forgot to leave those things to, they don't get a redo, and the stakes are too high because for you to not do it and to do it wrong. Because I used to also think before I got into this, what's wrong with just printing off a will from the internet and filling it out, right? That should work just fine. I can write down. I know how to write. I'm not dumb. The issue is there's a lot of complex things that could need to be handled, right? And we haven't got into a lot of those in this presentation, but things like, what am I supposed to do with my retirement or my investments or my house, or should I just deed it to my son so that he can give it to everybody else? No, the answer to that question is
the answer to that one's no. Don't do that. Don't do things to your kids and tell them, oh, I'm sure you'll be fair.
Right.
Don't do that.
Right. But there's a lot of complex things that need to be taken care of, and that's what we do. We help you with all those complex questions, and we have a lot of experience doing that. And so the stakes are too high to try to take a risk and just do it on your own. I mean, frankly, it's possible. It totally is possible. You could totally do it on your own. But it's just not worth it. It doesn't cost that much. An estate plan, the cost that it takes to actually have us draft it for you, it's not that much, and absolutely worth it. To avoid all of these conflicts that we're talking about later, there's no question in my mind that a little bit of preparation will go a long way in the long run to avoid litigation.
And just to be a little bit clear about kind of what we're talking about here, a little more specific. To come in and get a professional estate plan done, depending on exactly what you need, and there are different types of plans for different people in different circumstances, and we may be able to talk about that a little bit later in this presentation, but the cost you're looking at incurring is in the hundreds or thousands of dollars range, and the cost in attorney's fees of some of these little litigated cases is in the tens of thousands or hundreds of thousands of dollars is not an exaggeration, okay? And the hundreds of thousands of dollars in attorney's fees case, that the cases that routinely cost that in attorney's fees, those are not necessarily huge cases. $100,000 in attorney's fees might be spent in a $300,000 estate. That's just a house.
Right. I mean,
a small house right now.
Yeah, that case that we talked about earlier, where the city ended up suing the heirs. The lawyers ended up taking about $300,000 of that relatively small estate. It wasn't even worth
not that big of an estate.
It's less.
Yeah.
And so lawyers got most of it.
So that's the scale that we're talking about here. And I always tell people, look, it's worth a few $100 to save yourself $30,000. Well, not yourself. Save your kids $30,000 in attorney's fees. And more importantly than the attorney's fees, I have way too many people in my office who tell me that they will never speak to their siblings again over this. I hear way too often, I didn't think it could happen to our family. And guess what? It can happen to your family. So come in and we can see what we can do to make sure it does not happen to your family. I mean, we can't make sure, but...
Right. Well, I like to use
the best we can do.
Proper preparation helps prevent problems. Preparing an estate plan properly helps so much in avoiding conflict among your children or your heirs, whoever you want to leave your things to later on. If that is very clear, if it's written down, it's easy, simple, and predictable. those relationships, which for most of us are what we really care about. I mean, our money comes and goes, but the relationships are what this life's all about, right? And so a little bit of preparation, proper preparation, will go a long way in avoiding those problems later.
All right, we got a little sidetracked. We're going to get back on track here. So we were be written down, be equal, be easy, be predictable. The last one, be dead. Stay dead. This is a webinar, so I don't know who laughed at that and who didn't. Dan laughed, so that's okay. I usually get a good laugh on that one. Be dead, though. I'm not saying don't exercise any control over your estate after you've passed away, but the less control you try to exercise, the fewer restrictions, the fewer requirements you put in your estate plan, the more likely you are to be conflict-free. We could turn that around too. The more restrictions, requirements, and other things like that you put into your estate plan, the more likely there is to be conflict. So, again, I keep coming back to this. I harp on this all the time. In my mind, the best estate plan for avoiding conflict is sell everything, divide it into equal shares for all the kids, write checks, be done. Okay. Now, I understand that is not always going to be a perfect fit for every family and every situation, but you need to understand that if we deviate from that, the more we deviate from that sort of ideal plan, the more likely we are to cause conflict, and you have to be ready for that. You have to know that is a possibility. Now, certainly there are circumstances where you're going to want to exercise a little bit of control after your death. If nothing else, you want to say who gets money, right? I mean, that's probably the most basic thing. If you have a child who is, for example, disabled or has special needs, well, that's a circumstance where you may not want to give them their full inheritance. Maybe because they can't handle it. Oftentimes what we're looking at in that situation, though, is making sure that they remain eligible for government benefits. So there are things that we can do to make sure that happens. If you are worried about creditors, certainly there are steps we can take to protect your assets from your children's creditors. But again, the more restrictions, the more requirements, the more safeguards like that we put in place, you just need to be aware that raises the odds of conflict. It puts more control in the hands of the trustee or the personal representative of your estate, and your kids are going to probably have a problem with that. They are not going to want to go to older brother every time they want money from their inheritance. That causes problems. So again, these are not hard and fast rules. They are guidelines. They are tips. They are, hey, if your number one concern is avoiding conflict, here are 5 things you can do to minimize the odds of conflict. Certainly it's not a guarantee. I have seen and participated in cases where just the absolute stupidest things were fought over. But these are the main areas where I see problems. And to be honest, they're things that are easy to catch on the front end on the planning side. And that's another reason why we think that we're qualified to help with this, is because we've done so much of the fighting that we hope at least that we can take that experience and translate it over into avoiding that conflict in the future. We can say, hey, this is where I see problems. This didn't make the list. It is something that I talk to people, and certainly something that people ask about sometimes. They say, what if I have 2 trustees? What if I have 2 executors? What if I just make all my kids the trustees of my trust? And I always say, I mean, I can do that if you want me to and if you have a reason to, but I don't recommend it, because that's just, the more people you make trustee, the more cooks you're putting in the kitchen. And again, the bigger the odds of conflict are. Now, again, like all of this, that is not to say that there are not exceptions, right? I see that actually a lot in blended families, where it's like, hey, we need 1 kid from each family. We need 1 kid from my wife's family and 1 kid from my family to be the trustees. That's the only way to make everybody feel comfortable, and that's fine. And I do that in that circumstance. But again, just because we're doing it doesn't mean that it's not going to be a problem. Like that increases the odds of conflict. It's just that we've identified, but there'll be a bigger conflict if we don't do it. So I totally lost my train of thought with all of that. Where was I going? I think I was about to wrap this thing up, but I can't remember.
We were just saying, be dead. Don't.
Yeah, be dead.
Control.
That's right. Okay, so we are getting ready to wrap up. Some of you guys, I think, have been posting some questions as we go. Does not look like we're going to have time to answer some of those. please just get in touch with us. We're happy to answer those one-on-one. I see a few that I would actually like to talk about, and I just don't think we have time. So please just get in touch with us. We will make an appointment and answer every question that you have. Okay, but before we go, I do want to talk real quick about a few of your estate planning options. There's two basic forms of estate planning: will-based estate planning and trust-based estate planning. This is not the time, and we do not have the minutes left to get too deep into the weeds on those. I think probably what we should just tell you guys for now is, hey, a will is cheap, easy to set up. It's the bare minimum. If that's all you can afford, then we should do that. It's fine. It's the bare minimum, but it's the bare minimum. Let's do it. And let's get that level of protection at least, okay? The other option is a trust. Those are actually the more popular one. We do more trusts than we do any other type of estate planning. They are more expensive to set up. They're easier to use on the back end. A will needs to be probated. A trust does not need to be probated. A will is good at a few things. A trust is good at many things. It's more flexible. So trust is definitely what we will try to steer people towards. Definitely what most people are interested in. But we do have a set of clients that a trust does not make sense for. And for those clients, we absolutely will do a will. So for example, often for younger couples with children, but very few assets, I will tell them, look, let's just do a trust. Let's just do a will. You don't need to spend the money on a trust. You don't have the money to spend on a trust. You need that money more than I do. And let's be honest, the most important thing that you're doing at your stage in life is nominating a guardian for your kids. And we can get that done for you in a will. So let's do a will. On the other hand, anybody who owns real estate, I always kind of lean towards a trust for. Say, look, real estate is not overly complicated to deal with in probate under a will. And again, remember, wills have to go through probate. That's a court process. You can't skip it if all you've got is a will. Real estate can be dealt with through the probate process, and I do it all the time, but it is a lot easier to deal with under a trust. So if you own a home, even if that's all you own, if you own other real estate, then yeah, even more we want to talk about doing a trust for you. But even if all you own is your home, there is a lot of benefit to going with a trust. A lot easier on your heirs, more money up front, less money spent on probate and court fees though. So it kind of all comes out the same in the end. So that is generally what most of our clients are interested in. But give us a call, set up an appointment. We can tell you what's right for you and we can take care of it. We try and make it as easy and painless as possible. That is my goal at the end of the process with every client, is that they say, oh, that was easy. And I don't know, it happens more than I hear that quite a bit. I'm not going to give you numbers because I can't remember them and I don't know them. Absolutely. But somebody just told me that last week. I was like, yeah, sweet. That's what I was going for.
Yeah, absolutely. I mean, generally the process is you call us, we talk about your needs and go over those things. I'll either give you a questionnaire to fill out or I'll fill that out with you as I talk. And then we'll draft a first draft of your documents for you. You look it over and we talk again and answer any questions, make any changes that need to be made. And then we sign them. And after it's signed, then if there are any other steps, we take care of those steps and you're done. So it's pretty straightforward, simple process. It just needs to be done. Just get it done.
Get it done.
Cool.
All right, that's it. That's all we got for you guys. Hope to hear from you soon.
Thanks for watching.